Good morning. It is March 27, 2025. This is the second regular docket of the Oil Conservation Division, primarily for status conferences, although we are going to have a motion hearing at the end of today's docket. My name is Gregory Chikalian. With me, I have Dean McClure as a technical examiner only for the final motion hearing. Do we have a court reporter?
Yes, we do.
All right, thank you. Let's get on the record in the order that I have them. I hope it's the order that you have them. I'm going to start with case numbers 25035, 37, and 38. These are Matador Production Company compulsory pooling applications. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador.
Thank you.
Good morning, Mr. Hearing Examiner. Darren Savage with the Santa Fe office of Aberdeen and Schill, appearing on behalf of Cimarex Energy Company.
Thank you.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak.
I know there's other parties that have entered.
Mr. Examiner, can you hear me?
I believe we have XTO.
Yes, can you hear me?
Ms. Vance, am I correct? Oh, there's Mr. Suazo there.
Can you hear me,
I think
Mr.
he's having
Examiner?
issues with his
I think he is too.
volume.
Okay. Let me log back in.
I saw Mr. Suazo. I believe he's here with us. Whether we can hear him or not is a different issue.
Mr. Examiner, this is Dina Bennett. Can you hear me?
Mr.
Mr.
Examiner, can
Suazo,
you
I
hear
can
me now?
see you, but I can't hear you. Do you want to use your
Okay.
phone or something else to
Yes,
to speak with us?
sure.
Freya, did you get the message from Dean? He says there's something about the speaker in Pecos Hall. People are talking virtually, but you cannot hear them.
Let me check.
Thank you.
Welcome to the audio conferencing center. Please enter a conference ID followed by pound.
I think it may be working now.
Okay.
After the
Mr.
tone-
Swaza, do you want to try?
Sure. Can you hear me now?
Yes, thank you.
Okay, good. Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing on behalf of XTO Energy in cases 25035 and 37 only, and appearing only for monitoring purposes.
Okay, thank you. I noticed that you had an objection and you withdrew it.
Correct.
All right, sounds good. So, Ms. Vance, this is a final status conference. I think we're set for May 13. Maybe we're not set for May 13. It's in my notes that I'd like us to be set for May 13.
Would it be, I think our preference would be to push to either a June or July contested
Okay.
hearing.
All right. Okay, let's go to Mr. Savage.
Yes, thank you, Mr. Hearing Examiner. Mr. Examiner, we did enter an objection on this, and after review of the facts of this situation, we object to MRC's believing they have a right to pool the east half of Section 10. And we think this is a rather serious legal question that has arisen in this case. So Cimarex has been looking closely at the economics of its east half unit. They own 97% in the east half of Section 10, and they have entered a JOA that controls 100% of the east half of Section 10 under a voluntary agreement. And Cimarex believes it would be economical to develop this as a discrete unit. So this creates a kind of an unusual situation for the division in this matter, because under the Oil and Gas Act, development under a voluntary agreement overrides and supersedes a party trying to force pool by using state police powers to force pool owners who have already volunteered to develop its agreed unit. So, how we're looking at this. So the parties come under the jurisdiction of the OCD when they can't reach a full voluntary agreement, and they have to force pool other parties. And then, so competing applications become under the jurisdiction of the OCD when both parties have to force pool. Okay, that allows at that point the OCD to decide which development plan is the one that would best prevent waste. But if a party has a JOA in place and has 100%, and it's a proper spacing unit, then that becomes a private matter involving vested property rights, and the operator can go ahead and develop that. And that's what Cimarex is at this point planning to do. So we think that setting a hearing date is really kind of outside the jurisdiction of the OCD at this point.
So, Mr. Savage, are you saying, and I want to be clear about the locations and the scale of what you're talking about, are you talking about the exact same area as this application?
So the application that MRC filed, it purports to pool stand-up 2 mile, Section 3, east half of Section 3, and the east half of Section 10. Okay.
How many acres are we talking about?
What is that? That's 640
Okay.
acres. And,
East half of both sections, 3 and 10?
that's correct.
Ms. Vance, is that correct?
And
So our applications, and I'm reviewing them right now,
Yes.
they pool the east half of sections 3 and 10.
Okay.
So it's more acreage than what Mr. Savage is referring to. He's specifically referring to some type of contractual agreement that his party has regarding the east half of Section 10. But we're trying to pool both the east half of Section 10 and Section 3.
Okay, I'll come to you in just a minute. I
Yep.
just wanted a yes or no if you agreed with his characterization of your application being the east half of sections 3 and 10. Okay, I'm with you so
yes,
far. Go
okay.
ahead.
And there's actually 3 applications. One
Yes.
is the east half of Section 3 and 10.
Yes.
And the others are the east half of Section 3 and 10, and the west half of Section 3 and 10.
Okay.
So it's all the east half of Section 3 and 10.
You lost me on that third application.
So the one application is the Bone Spring, and it's the east half of Section 3 and 10.
Okay, all right.
Okay. Then there's 2 applications for the Wolf Camp, and one of them is the east half of 3 and 10. And then the other is the east half of 3 and 10. So that also uncovers, those 2 applications also cover the entire east half.
In what formation is that second one you said?
So the first one is the Bone Spring, and the other 2 are the Wolf Camp.
That's what I was asking.
And they're all oil pools.
So ultimately, all 3, if you add up all 3 applications, you have that 640 acres in both the Bone Spring and the Wolf Camp. Okay, now what are you saying?
Okay, so Ms. Vance is correct. We have a joint operating agreement that covers the east half of Section 10.
Okay.
So that's what we're developing,
Right.
is the east half of Section 10. We're doing it under a voluntary agreement.
Right.
Okay. a JOA, once a JOA is formed, a JOA consists of a number of discrete property rights. But once the JOA is formed, there is good authority that says it itself becomes a property right.
Okay.
Okay. And then the operatorship rights in the JOA also become
Okay.
a property right.
So you're saying they can't be force pooled because they're committed. They're not uncommitted.
Right. They cannot be forced pooled because MRC cannot terminate a property right within a voluntary agreement.
I understand.
Okay.
Okay, I get it. So we're just talking about section 10 in the JOA. Section 3 is still, okay. Now, Ms. Vance, what do you have to say?
Well, I'm not even sure where to start, because first of all, this is the first I'm hearing of this from opposing counsel. It was my understanding that we were going to come here today and discuss and come to terms on a contested hearing. It's
May I make a suggestion then, since I understand you're a little bit blindsided by this. So, Mr. Savage, why don't you speak with Ms. Vance at some point? I'll recall these cases before the end of the day. You're both going to be here till the end of the day. So maybe you could take a few minutes sometime before the end of the day, discuss this, and then Ms. Vance, I'll ask for your
Thank
opinion.
you.
They are your applications. So, and were you saying the JOA is for both formations in the east half of 10 or just one formation?
Yes, it's for both the Bone Spring and the Wolf Camp.
So it completely occupies the east half of section 10 in both formations, your JOA.
That's correct.
And that's completed, that's signed, it's a deal?
Yes, it's signed, it's filed of record. It's actually a title document of record.
So then we'll let Ms. Vance have some time
Okay.
on these, okay?
I just want to be
Yes.
clear that based off of what Mr. Savage has said, this JOA that covers the east half of section 10, it's my understanding he said they have 97%?
No, 100%, I think you said.
So, well, in the JOA, a JOA is a voluntary agreement of interest, right? I'm trying to be as clear as possible.
So
We
Let him
own
answer your question.
97%, but we also have joined the remaining 3%, so it's 100%.
Well, that doesn't matter because it still competes with our overlapping applications. Again, I will gladly wait and have a conversation with Mr. Savage, but our preference, just so it's on the record, would be to set a contested hearing either June or July.
Okay, it sounds to me like, and Ms. Vance, you're asking for June or July instead of May, and we're still in March. Why do you want to wait that long?
It's my understanding there still are some negotiations going on in the background. So again, this is why I was blindsided, because I was under the impression that the parties were discussing. So this argument is completely new to me.
All right. I understand. I've been there before. Okay.
Thank you.
So, Mr. Savage, you mentioned that this is a legal issue in your estimation. So maybe filing motions, briefing this issue?
Yes, sir.
So that the division can make a ruling on this.
Yep.
But I'm still going to let the parties discuss this and come back. So we're off the record well, Mr. Suazo, do you have anything to say about this?
No, Mr. Examiner.
Did you know about this?
I did not.
Okay, thank you. All right, so we're going to be in recess on 35, 37, and 38, but we're going to come back to those a little bit later. Okay, so let's move on to 25151. This is VF Petroleum. Entries of appearance, please. Mr. Savage?
251.
believe
Did we skip something?
I don't know. Did we? I didn't think we did. I called 35, 37, and 38. Okay, this is number 4 on my docket. I get you have a different order somewhere.
No, this is Holiday Energy Law.
25151 is
Oh,
Holiday.
25.
The next one
Not
on
in my
our,
books, it's not.
the next one on our list is 25182.
Well, my list is in a different order, so so I have 25151. Freya, is that not on the? You have a different order for me. Okay, Freya. Is 25151 on the docket at all? Everyone seems surprised that I'm calling it.
Mr. Examiner, I don't see it on the docket, the version I'm looking at.
Wow, it was on the docket just a few days ago. Will you look up the case 25151, please? It's VF Petroleum. There was a status conference, Mr. Savage, Paula Vance for Apache. We were going to set a contested hearing. I mean, anyway, okay.
Okay.
Can you find out, Freya, what happened to 25151 for me?
Yes.
Because it seems to have disappeared. Okay, number 4 on our docket is 25182, Cimarex Energy. And your appearance,
Good morning,
please.
Mr. Examiner. Ben Holliday on behalf of the applicant.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador.
Thank you. Are there any other, Mr. Holliday, any other parties that you know of?
I believe EOG has entered an appearance.
Okay, is that Ms. Kessler?
Yes.
Okay. Ms. Kessler, are you here? Okay, Mr. Holliday.
Yes, I think this should be pretty easy. Ms. Vance let me know last night that they had withdrawn their objection
Oh, good.
to this matter by affidavit. And so we would just like to set this for the next available hearing by affidavit date, preferably the 10th.
Freya?
I'm sorry.
Mr. Holliday wants to move this, to continue this case because it is not objected any longer to the next hearing by affidavit date,
Okay, April 10th.
April 10th. Mr. Holliday, April 10th?
Yes, sir, please.
All right, Mr. Holliday, you'll move the case. And Ms. Vance, have you filed the withdrawal?
Yes, we
Excellent.
filed it yesterday.
Thank you very much. Mr. Holliday, anything further?
Nothing further. Thank you.
All right, thank you. I'm now going to call the Paloma Permian cases. There are many of them, 25187, 88, 89, 90, 91, and 92. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Michael Jewell Jimerson Natural Resources Law on behalf of the applicant for cases 25187 through 92.
Good morning, Mr. Jewell.
Thank you.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Devon Energy Production Company.
Devin, thank you.
Good morning, Mr. Examiner. Carrie Hatley, entering an appearance on behalf of COG Operating and Concho Oil and Gas.
Thank you. Mr. Jewell, are there any other parties that you know of?
Not that I'm aware. I think we have COG and Devon represented, so that's all that I'm aware at the moment.
Okay, Ms. Hardy, you objected to this case. Why?
Yes, Devon has submitted competing well proposals, and those were sent out in mid-March, and we would be filing competing applications that would initially be set, I believe, on probably the first May docket.
Oh, they won't make the April docket?
No, because the deadline's already passed for April. So we would be looking at filing for the,
But the deadline hasn't passed for the April status. I mean, it certainly wouldn't be on the April hearing by affidavit, would it? I mean, we know that it can't.
presumably not, right? But I think the proposals went out March 13th.
Oh.
So if we waited 30 days to file under
I
the
see.
typical practice, that would push those to May.
Okay,
So
the first May docket.
the first May
All
docket,
right.
yes.
How many cases did you file?
Well, they haven't been filed yet, but there are competing proposals. And I believe that they address all of the same acreage and that there would be a number of applications for specific spacing units for different wells. So it would be, I think, a number of
So
applications.
you anticipate filing the competing applications on what date did you say?
We would file them in time to make the May 8th docket. So by April 8th,
So 20 days before the April, sorry.
30
20
days.
days before the May docket.
30 days before the May docket,
30 days.
30
before May
for
docket.
filing.
We
yeah.
have to publish notice 20 days before.
Exactly.
And so do you, right?
Yes.
That's what I thought. Okay. All right. So then we're, Freya, when is the May, what is the May hearing by affidavit docket?
That's May 8th.
May 8th. Okay. So we have an idea that it'll be filed by April 8th then. basically.
Yes.
Okay. And then instead of waiting, Mr. Jewell, how do you want to proceed?
Conferring with counsel, it seems like we should have another status conference because our clients are discussing these proposals, and despite the competing applications, it sounds like we are negotiating in good faith, and our spring breaks had little bit of difficulty in getting our land teams online, but I know these applications are forthcoming, but looks like we have a good line of sight into seeing how we can move forward. So I think a status conference for April or May, depending on council's best interest here, would be advisable.
All right, I'll set a final status conference for May. That gives the parties 2 months further to negotiate. This objection was filed by Devin on March the 6th, so it's already been in the works for a while. So what will happen is these cases will be noticed for the May 8th docket, but then Freya, I think it's you who moves them to the second May docket automatically. Is that right?
Yes, once an objection is filed, I will move it to the May 22nd docket.
May 22nd for a status conference. Any reason, Mr. Jewell, that we shouldn't join Ms. Hardy's cases with yours?
I think that's logical. Sounds great.
Okay, we'll join them for the purposes of the hearing, and that'll be a final status conference. So the parties will either tell me that they don't need a contested hearing, or we will set a contested hearing, and it won't be far down the line that we set it. We'll probably look for June. So let me give you some dates now so you can actually think about them if negotiations don't go as you suspect that they will.
Great.
All right. We have in June the 10th. Well, we only have one day in June, and that would be June 10. So I'm going to make a note that I've offered you June 10 for a contested hearing, and we'll see how that works on May 22nd at the status conference. Anything further, Mr. Jewell?
I'm just checking real quick, but that sounds good to me, sir. Thank you.
Yeah, you're welcome. And welcome to the forum. Ms. Hardy?
Nothing further from me. Thank you.
We're off the record in these cases. Moving now to, Freya, did you find out what happened to 25151?
I did. It was, let me go back to it. There was an objection withdrawal on March 19th, so it was moved from the docket around that time.
Okay, so is it going to be heard by affidavit?
Yes, on April 10th.
Perfect. All right, excellent. Thank you for clearing that up for me. Okay, so moving now to number 11 on our docket. This is VF Petroleum 25193, entries of appearance.
Good morning, Mr. Hearing Examiner Darren Savage with Aberdeen Shell on behalf of VF Petroleum.
Morning.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Apache.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley on behalf of Marathon Oil Permian, Concho Oil and Gas, and COG Operating.
Thank you. Okay, let's
Sorry,
see.
Mr. Examiner Dana Hardy on behalf of Permian Resources Operating.
Thank you. Now, it's easier just to ask you, Mr. Savage, who filed objections in these cases?
So, Mr. Hearing Examiner, Apache filed an objection, but they withdrew it.
Okay.
And I believe Permian Resources, I believe, has an objection in place.
I see that it does on this piece of paper here. Okay, and that's you, Ms. Hardy, right?
That's correct.
What's your intention?
The parties have been negotiating. This acreage is involved in, along with other acreage that's being discussed by, I think, by Permian Resources and VF Petroleum. So we maintain our objection at this point. At this point, I think there's not a plan to file competing applications, although if the negotiations don't work out, then I think that's certainly possible.
Well, Ms. Hardy, how long do you want me to leave for negotiations?
I think that Permian Resources would be fine setting this for another status conference in another month,
Okay.
if that's acceptable
Okay.
to the other council.
Mr. Savage?
Yes, Mr. Hearing Examiner, it's my understanding that VF Petroleum has a significant amount of working interest and that Permian Resources has very little. I mean, Dana can, if I correct me if I'm wrong on that, but I believe that that is the matter. So we don't really see Permian Resources coming in and being competitive on the competing application situation. We would like a earlier contested hearing date. And if Permian Resources wants to, I think that obviously that's not their first interest and not their first pursuit for their interests. So if they want to do that, they can do that. But at least it would be set. The date would be set.
Okay. All right, well, Ms. Hardy, as you know, I tend to give preference to applicants when it comes to how we proceed, whether it's another status conference or whether it's a contested hearing. So the applicant's asking for a contested hearing, when, what month?
We would like an earlier one. So if there's something available in April, that would be great. I don't think there probably
The
is.
soonest one is May 13.
That would be perfect for us.
Okay. Ms. Vance, I'm sorry, not Ms. Vance, because you withdrew your objection. Ms. Hardy.
I would need to confirm with our witnesses,
Sure.
but
Okay.
for now,
Fine.
that sounds,
So we'll issue a pre-hearing order. Mr. Savage, do you want me to set this for another status before the May 13 contested hearing?
Yeah, that might be useful.
Okay. What about the April status conference docket? I don't know the date of it. Freya, do you know the date of the April?
I do. It's April 24th.
All right. So Mr. Savage, would you move? This is a single case, is it not?
Yes.
Okay. Would you move this case to the April? I'm sorry, what did you say, Freya? April what?
April 24th.
24. Mr. Savage, would you move this case to the April 24 docket for a final status conference, but we will also issue a pre-hearing order for a May 13 contested hearing. And Ms. Hardy, hopefully your negotiations work out. And if for some reason, Ms. Hardy, your witnesses are not available on May 13, let me know. I think we could find something else. I mean, I can't promise it, but we will look for something in that time frame, but before the June dates, because Mr. Savage would like us sooner than later.
And Mr. Hearing Examiner, I said perfect out of appreciation, but I do also need to check on availability just to, yep. Thank you.
I expect that, but the parties will file a motion if May 13 doesn't work out.
Yes,
Okay?
sir.
thank you.
Okay. And obviously, Ms. Hardy, if you file competing applications, we can add those to the pre-hearing order as well, as long as the notice thing works out.
Understood.
All right.
Thank you.
Okay, anything further, Mr. Savage?
No, thank you.
Ms. Hardy?
No, thank you.
Okay, very good. We're off the record in 25193. Moving on to number 12, BTA Oil Producers, two cases, 25194, 25195. Interest of appearance?
Mr. Examiner, Dana Hardy on behalf of BTA Oil Producers
Thank you.
LLC.
Mr. Examiner Matthias Sayer. Mr. Examiner Matthias Sayer on behalf of, from Bradford Sayer on behalf of Quatera Energy.
Otera. And how do you say your name?
Matthias
Matthias? What last name?
Sayer.
Sayer? Sayer, thank you.
Good morning, Mr. Examiner. This is Dina Bennett at Model Sperling on behalf of Avant Operating 2.
Avant, thank you. Ms. Bennett, did you file an objection?
I did file an objection
Okay.
on March 4th, but I withdrew the objection on March 13th.
Oh, thank you. Okay.
So
Thanks for
monitoring the case.
monitoring. Thank you, Ms. Thank you, Ms. Bennett. And Mr. Sayer, did you file an objection?
Mr. Examiner, yes, Quatera did file objections in both cases.
All right. And on what basis did you file an objection?
Quatera Energy is preparing well proposals as competing cases.
You're gonna have competing applications
Correct.
in the whole same area, or will it be overlapping?
My understanding is it's the same area.
Ms. Hardy, were you aware of that?
I was aware that was a possibility.
Okay. Okay. How do you want to proceed?
Well, I think that BTA owns the vast majority of the interest in its proposed units, over 77%. So they are ready to develop this acreage and are prepared to do so and would like a hearing date as soon as possible.
Okay. Let me see what notes I have here. There we are. There we are. That's true. Okay. And Ms. Hardy, when were your cases filed?
Oh. Would have been, I think this is the first docket setting for them.
So they must have been on for earlier March, but then they were bumped to later March because of the objection that Mr. Sayer filed possible, or maybe even
Correct.
Avant filed.
Yes, that's correct.
All right.
So they
So
would
they
have
were
been
filed in February.
in
then
February.
maybe?
Yes, that's correct.
Very
February,
good.
early February.
Okay, Mr. Sayer, Ms. Hardy wants a contested hearing, but you said you were sure that you're filing competing applications?
Yes, Mr. Examiner, we have well proposals that are being sent out early next week.
Oh, they're just now being sent out. So then if I'm not mistaken, we need a month before you file those here at the division. All right, so then if we have early April, then we have early May, and then that's going to be early. Okay, well, Ms. Hardy, now, Ms. Hardy, correct me if I'm wrong, but if they file, well, we still have to provide 20 days notice of your filed applications. And if that's not till, so it looks like June, Ms. Hardy, it looks like June would be the earliest we could set this as a contested hearing based on the competing applications.
I think that they could file earlier than that
Uh,
if the notice period could run concurrently, or the proposal period, which happens occasionally.
Lay it out for
We
me.
do that.
He just
Well-
said that next week they're going to mail out the proposals to you.
So that's first week in
Right,
April.
Right.
I suppose then they could file for trying to think of the timing here. For the first, they would be filing for the first May docket. I mean, if you propose the wells and filed and the notice period ran at the same time as that was pending that. And I think that, here BTA they filed February 11th.
Okay,
So we would be looking at, if we're looking at a June hearing, 4 months after
I agree.
filing.
Well, you know me, Ms. Hardy, I'd like to have
Yes.
hearings right away.
I know.
But I want to be careful about the notice issue. So you're suggesting that Mr. Sayer could provide notice for a early May docket, and the division could too, but he wouldn't have filed those applications with the division. So how would Freya notice those?
Well, what I'm thinking is that, so there are two issues, right? There's the proposal period. You send out well proposals,
Right.
typically wait 30 days, but that's not necessarily required in all
Right.
circumstances.
Right.
And then there is the mandatory 30 days
Right.
before filing, right? So if they're sending out well proposals next week, if they got them out early in the week, which it sounds like they could do because they know they're going to file them. So they could send those out early in the week and then file their applications by April 8th
I see.
for the May 8th
I see.
docket.
Okay. Mr. Sayer?
Yeah, Mr. Examiner, so we would essentially be curtailing to some degree or limiting the period for the well proposals. The 30 days is what's being
The
suggested.
policy of the division is to allow parties to have 30 days basically before those are filed. However, they're already competing applications anyway. So I think that policy can be adjusted in that case. But I'm asking you, are you objecting to that? Are you agreeing to that? What do you say?
I think as an initial response to that, our kind of preference would be that we have 30 days for the well proposals, and then, the statutory 30 days for the applications.
So, Ms. Hardy, it looks like, based on the objection to your creative thinking, it looks like June will be the earliest we can hold this as a contested hearing. So we have June 10, Mr. Sayer. Does that work?
Mr. Examiner, that works.
Ms. Hardy?
We can, I believe we can make that work.
All right, sounds good. So, Mr. Sayer, what I'd like you to do is, when you file your applications in a month or so from next week, please file a motion to consolidate those cases, join them with the pre-hearing order that we're going to issue in Ms. Hardy's cases, excuse me. So I'm going to issue a pre-hearing order in the 25195 and 94 for the June 10 contested hearing, and then we will join your cases, Mr. Sayer, once they're filed with a motion. and we'll amend the pre-hearing order at that time, but we're going to keep the date of June 10. Obviously, if it doesn't work for your witnesses or Ms. Hardy, you'll let me know. We'll find a day around that time, but we're not going to make it later than June 10 because Ms. Hardy's applications were filed in February, and we like to move these things along.
Yeah, Mr. Examiner, understood. Thank you.
Anything further?
No.
No.
Thank you.
Thank you very much. All right, we're off the record in those cases. Let's move on to Mewbourne oil cases. We have many of them, but we're only going to deal with the first two at a time. 25217, 25218. Entries?
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Mewbourne.
Thank you.
Mr. Examiner, Darren Savage on behalf of Devon Energy Production Company, LP.
Mr. Savage, did you object?
We did.
You did. Okay. When did you object?
It was, I don't know, a few weeks ago.
Okay, all right. What's the basis of the objection?
The basis of objection is competing applications.
You have them now, or you?
We have sent out,
Oh.
so well, for one set of the cases, we have sent out well proposals already.
Okay.
For the other set, we also sent them out, but we FedExed them
Okay,
yesterday or the day before.
great.
Mhm.
Okay. So when you say one set of case, you mean one case you've already sent them out and the other case you FedExed them?
That's correct.
Okay, very good. And does it overlap exactly, or does it cover the same acreage?
I believe it does.
Okay.
There's some variations in there because I believe we have a longer lateral in some instances, and
I see.
so
Ms. Hardy, were you aware of the competing applications?
I was not aware that they had sent out proposals. I knew it was a possibility,
Okay.
but
Well, you've learned today that
now I know.
you've learned,
Thank you.
you've learned it. All right. So Ms. Hardy, how do you want to proceed?
Mr. Examiner, Mewbourne and Devon are negotiating, and so I had discussed with Mr. Savage, and I think our clients have agreed that we could set these for another status conference, and we'd be willing to do that on the May 22nd docket if that works for the division. I think that's the May status conference docket.
It would be, yeah, that'd be almost 2 months from now. So you want to wait that long? Okay.
That's fine with the parties.
All right. So we'll put this down for a status conference, May, you said 22nd, didn't you?
Yes.
Okay. And that'll be a final status conference. So I'll let you know now. And by then, so Mr. Savage, with the mailing thing you just said, you're going to file your cases in about a month, basically,
that's correct.
2 cases, basically.
I'll have to look at enough cases to cover make it a competing application.
Fine.
Yeah.
Will you file a motion to join those 2 cases with Ms. Hardy's cases? So
Yes,
we
sir.
can track them together. And then at the May docket, I'm going to want to set these for a contested hearing if in fact the parties still need a contested hearing. And we'll be looking at July 1st or July 15. I'm going to throw those 2 dates out now. 7/1 or 7/15 contested hearing. That's what we'll offer you for these
Okay.
cases. Anything further, Ms. Hardy?
No, thank you.
Mr. Savage?
Thank you.
All right, excellent. Let's move on to other Mewbourne oil cases, 25228.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant Mewbourne.
Thank you.
Mr. Examiner Matthias Sayer from Bradfute Sayer on behalf of PVEX.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley entering an appearance on behalf of ConocoPhillips and COG Operating.
Thank you. Ms. Hatley, are you monitoring?
We are monitoring only.
And PBEX, are you objecting?
Mr. Examiner, we have PVEX will be filing completed or competing applications tonight.
So did you object?
I believe objections were entered, yes.
Okay, but you yourself didn't.
I did not, no.
Okay. Ms. Vance, what do you know?
Well, I believe one of the things I talked with Mr. Matthias's co-counsel, and we discussed setting another status conference for the April date.
Okay.
So
But-
that's what we'd like to
But
do.
I'm still not getting an answer to the question I asked.
I'm sorry, I was
Are you-
trying to do 2 things at once.
Are you aware of the objection?
Yes.
Was there an objection filed?
Mhm.
There was.
Yes,
By what? Ms.
correct.
Bradfute?
Miss
Oh,
Bradfute.
she filed it. Okay.
Mhm.
Mr. Sayer, I'm going to be asking, if you're stepping in for Ms. Bradfute, I'm going to ask you these questions. We do have an online imaging system, so you can always look to see what you have filed or what your co-counsel has filed. Okay. And so I believe you just said, Mr. Sayer, that you believe PBEX is going to send out competing application
Yeah, file competing applications today.
today. Okay. Did you say file it or did you say send out the proposal
File.
here in the division?
Correct.
Okay. Well, okay. Ms. Vance, how do you want to proceed? Oh, you said you wanted a status conference in April.
Yes.
Okay. Do you feel that's enough time to negotiate?
Yes.
We'll have a status you'll move your case. Your case, Mr. Sayer, if you file it today, it should just, no, it wouldn't work that way, would it? We would, so Freya, what would happen with Mr. Sayer's brand new case that he's filing today?
It would be placed on the May 8th docket.
Okay. All right, Mr. Sayer, will you file a motion to consolidate that case with Ms. Vance's case so we keep them together?
Mr. Examiner, we can do that.
All right, and at the April 23rd status conference, even though your case has not reached the notice period yet, I am going to ask if you're prepared for a contested hearing at that time.
Understood.
All right. And we can set it in July or something like that, whatever works for the parties. I'm not rushing it, but I do want to keep track of it that way. Anything further, Ms. Vance?
No.
All right, thank you. Let's move on. We're off the record in that case. Mewborn has two more cases, 25234 and 25235. Entries, please.
Dana Hardy on behalf of Mewburn.
Thank you.
Darren Savage on behalf of Devon Energy Production Company, LP.
Thank you.
Michael Rodriguez on behalf of Civitas Permian Operating LLC.
Okay, thank you.
And Carrie Hatley entering an appearance on behalf of COG Operating and Concho Oil and Gas.
And Ms. Hatley, are you monitoring?
Monitoring only.
Okay, Mr. Rodriguez?
We filed an objection, but I think streamline this. I believe the parties that have filed objections and the applicant have agreed to a May 22nd status conference.
Okay, so you're not withdrawing your objection?
No, we're going to maintain it for now.
Okay, all right. So you're hoping for a May 23rd status conference. All right. What about you, Mr. Savage?
Yes, these are seem to be related to the other Buffalo cases, and we also would hope for a May status conference.
Okay, let's go back to the question at hand. Did you enter an objection?
Yes, we did.
Okay, you did, and you're maintaining the objection.
Yes, we have competing applications in this.
You have competing applications.
Oh, we'll be filing competing applications in this.
The proposals were sent out?
Proposals were sent out about 2 days ago by Federal
Okay.
Express.
Okay, very good. So let's see. So Devon has competing applications. They'll be filed in about a month. That's right. So they'll end up on the May docket.
Those would, so 30 days for the well proposals, and then they'll be filed in a month. Correct. Thank you, sir.
Right. Oh, so they won't make the May docket, you're saying? They won't make the May docket.
No.
They'll make the June docket.
Yes.
All right. Well, we're going to come back on May 23rd. So, Mr. Savage, when you file your cases, how many are we talking about? Two?
I need to sit down and look at the development plans and see exactly how they're wanting, to space these and all that. But at least two.
At least two.
At least two.
That's fine. So when you file in a month, when you file your applications with the division, would you file a motion to consolidate those cases with Ms. Hardy's cases?
Yes. And we move those to the status conference.
We will do that.
Okay.
Because we'll know that they're contested based on the fact that they're competing with Ms. Hardy's, and Freya will automatically move them to the June something or other docket. But in May, we'll look to set a contested hearing date, probably for July. And but we'll see how things go, I guess.
Yep.
So Ms. Hardy, May 23rd, you'll move your cases?
Yes,
Okay, and does that work for you, May
That-
23rd?
yes, that does work.
I
Thank
know
you.
everyone else suggested it, but they are your cases.
I think it's May 22nd.
I'm sorry, I said
But
May 23rd.
I think everyone was saying May
apologize.
23rd, but it is the
You're
22nd.
correct. You're
So that, and that's fine with
Very good.
Newburn. Thank you.
Well, thank you. Okay, we are off the record in those Mewborn cases. I now you haven't had time to talk to Mr. Savage yet about those first three cases yet.
We had one bit of correspondence.
Did
I've
you?
been corresponding with
Oh,
my
oh,
client.
email.
I do have one follow-up. If we could take maybe just like a 5 or 10
Yes, of
minute
course.
break,
Sure.
that would be
Let's do
appreciated.
that because then we're going to go to the motion hearing.
Yes.
And anyone's witnesses who are available, I recommend that you let them know that we're about to start that hearing. Is there anything else before we go to the motion hearing? I don't hear anything. Okay. Thank you. We're off the record for 5 minutes.
I'm ready, just when you turn your mic on.
Okay, we're back. We're on the record now, and we are going to have a motion hearing in the following cases. These are Permian Resource, VF Petroleum, and Carolyn Beal is intervening in some of these cases. I'm going to call the cases 2494142, 2499495, 251151617, 25145464748. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian.
Thank you.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Abity and Schill, appearing on behalf of VF Petroleum Incorporated.
Thank you.
Good morning, examiners. Caitlin Luck on behalf of Carolyn Bell.
Oh, do you say Bell? It's not Beal?
I think it's Bell, but I could be wrong. I'll defer to Mr. Savage. His client is Mr. Tom Bell, I think, but I could be wrong.
It's Bell.
It is Bell, huh?
Believe so.
I've been saying Beal. Okay, I'll just
I've been saying Beal too.
Okay.
Well, there used to be that clothing store named Bell's, like, it was like a little department store. I think it's like that, but I'm not totally sure. But I think it's Bell.
Usually when I see Bell, it's Bell, and here it's Beall, and that's why I've been saying Beals. But anyway, very good. Thank you very much. Okay, so let's talk about where we are, and then let's talk about these motions, and let's proceed from there. So first of all, and Ms. Vance, don't let me forget to recall those first three cases, okay?
I will not.
Because I want to deal with those before we finish for the day. So first of all, these are competing applications between VF and Permian, and Ms. Bell seems to be on the side of VF, and we have had 2 full days of testimony. The first one on January 28 and the second one on February 27. Witnesses appeared for all parties, including Miss Bell. You had Mr. Shaw, if I'm not mistaken. Is that right?
That's correct, yeah.
Okay, very good. Parties were instructed to supplement their evidence by Mr. McClure, our technical examiner. And there was quite a long list of information that he requested from Ms. Vance. He did request a few things from Ms. Luck, but nothing from Mr. Savage. So that's how I remember. And I reviewed the transcript before today's hearing very carefully. So the parties did file supplemental exhibits. They have been reviewed. And then we had some motions come in. And 2 of the motions deal with a opinion letter that Ms. Vance filed as a supplemental exhibit C12 to her hearing packet. And we also have a motion to strike filed by Ms. Vance on behalf of Permian, asking me to strike the intervention of Ms. Beal's interests in one case, 25146. Now, as I remember the cases, 25145, and these are Reed Stevens cases, 24145 is the north half of section 14. 25146 is the south half of the north half of section 14. Ms. Beal claims an interest in both of those cases, and the motion to strike is based on this opinion letter that was submitted. Do I have that right so far, Ms. Vance?
Correct, along with Ms. Beal's expert witness testimony.
I understand. Thank you. Okay. Now, we also have Ms. Beal's motion to strike, pages 165 through, and there's a typo here, Ms. Luck, you have 176, but I think you meant 167.
Yes, that's correct.
Yeah, you did that a few times in here, but I understood you to mean basically the opinion letter. You felt it was unfair to file that at that point of the hearing, and you want me to strike it.
And also that the only basis for it being submitted is for a request for a title decision.
Which is outside the division's jurisdiction. You made it quite clear in your motion. I'm just sort of generally going over these things as to give context to anyone who might be listening. We also have a motion to strike filed by VF. Now VF's motion goes a little further than Ms. Beal's motion. And I will deal with them in the order that I want to deal with them. So today, we're going to start with Ms. Vance's motion to strike because it affects Ms. Beal. It affects her participation in case number 25146. And based on that, it affects her motion to strike, et cetera, et cetera. So Ms. Vance, what I have here, I have summarized your motion. And here is how I have summarized it so that you don't have to. And of course, the parties have all filed responses to each other's motions, and we have those as well. Okay. Ms. Vance, I'm going to summarize your motion and tell me if I miss anything. At the January 28, 2025 contested hearing, the division hearing examiner ordered Ms. Beal to file a notice of ownership interest in the cases she either owned or claimed to own an interest. Ms. Beal filed a notice of ownership interest and objection on February 6, 2025, which included title instruments. At the February 27, 2025 contested hearing, Ms. Beal late filed exhibits, which I allowed, including an additional instrument related to a claimed interest in case 25146. Questions arose from the division's technical examiner, Mr. McClure, who's with us today, about Ms. Beal's claimed interest in 25146, and Ms. Beal's witness confirmed that the interest could not be substantiated. Ms. Beal, this is a summarization of the assertions in the motion. I'm not saying that this is what we have found. This is just a summary. As part of Permian's revised hearing packet requested by the division technical examiner at the 27 February contested hearing to clarify the location of the debt severances and the affected parties, Permian included a title opinion in response to Ms. Beal's late filed exhibits. The title opinion also confirms that Ms. Beal does not own an interest in Permian's case 25146. That's the summary of your motion. Does that effectively capture?
Yes, and may I add?
Yes, go ahead.
Just a couple of things?
Yes, please.
One, regarding the notice of intervention that was originally filed by Ms. Beal, Ms. Bell, sorry. So Permian, this is the first motion to strike that Permian has filed. I just want to be clear because it seemed there was a little bit of confusion on the other side. This is our first motion to strike. In our response to the notice of interest with regard to case 25146, we said we have not seen any instrument in the record to substantiate this claim, but otherwise we stayed silent and said we would be prepared to discuss on the record at the next hearing.
When did you file that response? Just to be clear.
That was just after, I don't have the exact date, but that was right after, it would have been before the initial hearing, because we had a motions discussion, a preliminary motions hearing at that contested case in January.
But it was before Ms. Beal filed the ownership interest document on February 6th. Is that correct? That's what I'm trying to figure out.
Okay. So,
You want to look it up just to be clear?
yes, I want to be very,
Unless Ms. Beal, do you know when, Ms. Luck, Ms. Luck, do you know when that response was filed to your entry of appearance and objection, I suspect?
Well, I think that the notice of interest and objection was filed early February, and then their response was filed February 13th to our notice of intervention and the ownership interest or the objection, sorry.
that sounds correct.
Okay.
So we had a preliminary hearing, as I
Yes.
recall. The examiner asked for Ms. Beal to
Yep.
substantiate this interest. The notice of interest was filed. We filed a response. We had a discussion at the January hearing, and that's when a decision was made to allow Ms. Bell to have her notice of intervention in those two cases.
Yes, and I based it on the rule, which I laid out.
Mhm.
So anyway, we're going back to the summary I gave of your motion.
Yes.
What did I not capture?
So what I wanted to make
Yes.
sure that is in there for full understanding is that in our response, we made clear that we were uncertain about this
Okay.
interest up to that point, but we would be prepared to discuss it at the next hearing,
February 27 hearing.
the February 27th hearing, with the understanding that it is not Permian's job, it is not my job to clarify Ms. Bell's interest.
Mhm.
Understanding that Ms. Bell would be filing something or either reaching out to me, counsel to counsel, to substantiate this claim. None of that happened in that month-long period plus
Okay.
to understand whether or not she truly had an interest in the south half of the north half.
Now, let me stop you right there, Ms. Vance. Now, I think all the parties here agree, and I think the division also agrees, that it's not the division's jurisdiction to figure out who has an interest and who doesn't have an interest.
Absolutely. And I think I made that clear in my
Yes,
filings
you did.
and I have said it on the record repeatedly, that the division does not have jurisdiction over title.
And we all agree on that.
Okay. And so when we get to the February hearing, it's at the February hearing that Ms. Bell enters this exhibit that we have not seen, that she is relying on to substantiate this claim that she has an interest. And up until that point, we haven't heard anything from Ms. Bell.
I understand.
I
understand.
And so at the hearing,
You're trying to justify why you filed this opinion letter on March the 6th. Is that right?
partially.
Partially.
And look, we immediately got that, this document from Ms. Bell. She filed it as a part of her exhibits. And of course, what would we do? We're going to look at it. It was sent to our title attorney to evaluate it, to determine the veracity of it. But of course, we came back with the same conclusion that her own witness, Mr. Shaw, stated repeatedly on the record, which is they cannot substantiate it. There are gaps, there are clouds. They have no way of confirming she has an interest.
I remember the testimony. We were all here for it. We have a transcript file, so I'm not getting into that part right now. What Mr. McClure is concerned about are the def severances in the different parts of section 14.
Understood.
And I can understand that your document would be related to depth severances, because if you don't own an interest, then we don't have to worry about a depth severance.
Exactly.
I can understand that part. So I'm not.
And in that respect, it was not filed to have a title dispute, because again, we
I
agree.
understand that. That's why I just said that. Okay, I'm with you. Okay, so I've summarized your motion. I don't think I've missed any of the critical points. We do have Carolyn Beal's response to the motion to strike. And I'm going to summarize that too, Ms. Luck, for efficiency here. First of all, you make some procedural objections. You say that the hearing examiner previously allowed, wait a minute, I want to make sure. Yes, this is your response. That the hearing examiner previously allowed your intervention in the case on February 14 after you filed your notice of ownership interest and objection on February 6. Permian has not properly filed a motion for reconsideration of that decision. Instead, is attempting to re-argue the issue by filing a second motion to strike, which is procedurally improper. Permian also failed to request a rehearing for the commission or follow proper procedures. And here we differ, Ms. Luck. I know you think that you have the right to file an appeal before a final order is issued by the division, but I've cited to you the rule 1915-423, which clearly states that a final decision is appealable after the hearing is over, and that we're not there yet. So I'm not going to continue with that part of the procedural objections. Then you talk about substantive arguments, Ms. Luck. You say that it's a jurisdictional issue, that OCD does not have jurisdiction to decide title disputes. Everyone agrees with you, Ms. Luck. And you cite the Continental Oil versus the Oil Conservation Commission. Our jurisdiction is limited to preventing waste and protecting correlative rights, not adjudicating property ownership. Then you talk about your ownership claim. You assert that your working interest in the third Bone Spring was properly documented in your notice of ownership and supported by testimony by landman Jordan Shaw. Okay. Then lastly, you talk about improper evidence. The only basis for Permian's motion is a title opinion included in supplement exhibit C12. However, the document was submitted after hearing had already concluded, never subject to cross-examination, making it improper basis for striking Beal's intervention. Does that sum up your response?
Yes, that sums up my response. And the important issue here is that this is a quiet title matter that Ms. Vance wants to be determined here at the OCD. There's no dispute regarding the fact that there may be gaps in title, and an interest owner can own an interest despite the quiet title proceeding not having been completed yet. There can be gaps in title. And I think there's a fundamental misunderstanding about, Mr. Shaw's testimony at the hearing and what led us here. The proof of her interest was provided prior to the February 27th hearing. An additional documentation that filled in some of the gaps was provided at the February 27th hearing just to properly establish that she did have an interest in the south half of the north half case.
And you don't disagree with me that I allowed you to file that on the day of the hearing?
Yes, Mr. Hearing Examiner.
Okay. That everything you said goes to what's properly in a district court and not here at the hearing. What we are trying to figure out as a division so that we can make a judgment call on who has the better competing compulsory pooling plan is whether or not there are depth severances in different parts of Section 14. Your claim to ownership in Section 14 matters based on the depth severances. Do you understand what I'm saying?
Yes, it was my understanding that Technical Examiner McClure requested locations of those depth severances and how they came into being. And Exhibit C12 does explain that, but then the title opinion is where this pushes beyond the reach of the division's jurisdiction. There was a exhibit that was filed with their supplemental exhibits that had just a map, just the locations of the depth severances. That's located at page 164. And this seems to be essentially what Mr. McClure was requesting. Mr. McClure never requested a title opinion that gave a definitive answer about how title ran into Ms. Bell. That's something for a district court to decide.
Well, I'm going to leave that to Mr. McClure and his questions of Ms. Vance's witness. So, okay, then we have the response to Permian's motion to strike. And I have summarized that as well, Mr. Savage.
I'm sorry, what?
Then we have your response to the motion to strike filed by Ms. Vance. And I have summarized that as well.
Yes, please. Thank you.
Okay. Okay. So basically, Mr. Savage, you assert that the division has already ruled on Ms. Beal's participation and that her involvement contributes to the protection of correlative rights. You argue that Permian disregarded the examiner's specific instructions by not providing the requested landman's statement or actual title documents, instead submitting an unauthorized opinion letter. You contend that Permian was aware the opinion letter was unauthorized and irrelevant, as Permian's counsel had previously acknowledged the lack of jurisdiction over title issues. You further argue that Permian's motion to strike Beal's intervention reveals Permian's improper motive for submitting the opinion letter, which is to induce the division to adjudicate title and ownership. You assert that the protection of correlative rights is a substantive reason for the division to have granted Beal's intervention, and you request that the division grant your motion to strike, et cetera. Okay, so does that, I could go on.
Yes.
And because you actually went through the transcript and you actually pointed out, here Mr. McClure asked for this. I know I carefully reviewed everything you filed and I summarized it here, but I don't know that I need to go into that right now. But do I capture the gist of your response?
Yes. Yes, but if I can enhance a little bit on.
A little bit.
Okay. So it looked to VF that the request was of the title document was not for any review of title or ownership. It was for finding the locations of the wells. Now they did provide a diagram and they listed locations, but there is no substantiation. Where do those locations come from? The letter opinion does not provide any description of those depths, 9,400 feet. So it seems completely gratuitous, and that going through and clarifying the dialogue from the transcript was why we spent so much time in the beginning.
Well, I summarized that, so I'll continue then. According to the document, the examiner specifically asked for 1, additional testimony or written testimony from the landman describing all depth severances, including Ms. Beal's. 2, a document showing the 9,397 foot depth severance in the southeast quarter of the southwest quarter. 3, if a document was available, the examiner wanted to see that document. 4, if no document was available, then the description of the depth severances. 5, the examiner clarified that the title document was requesting should be A, something referenced to some well, B, related to some sort of depth severance, C, a document with some sort of ownership that ends at approximately 9,400 feet.
And then the important thing is number 3, and that is the preference to have the title document instead of the description, because the title document, provides that location information of title. And I believe that Permian have those title, and they have those title documents, but they didn't provide them.
Okay, well, that's okay. All right, thank you. All right, so okay, now I am dealing with the motion to strike that Permian filed, and we are going to resolve that with evidence. So we have the opinion, Lear and Lear opinion from Mr. Hubble. Do we have Mr. Hubble on the screen?
He is not available today. Unfortunately, he is out and not available. We did try to get him available and would just say, if we need to provide written testimony, we are certainly prepared to do that. I did not want to file any revised anything until we had a discussion today, but we will certainly.
Not available.
Not available.
And Ms. Luck, your witness is not available either, right?
That's correct.
Okay.
Unfortunately, Mr. Shaw's at his appointment for citizenship, but we would ask the same courtesy if the division requests evidence that we would be able to submit a supplemental land statement
Sure.
from Mr. Shaw explaining gaps in title and his interpretation of the title opinion.
Okay, well, I'm not interested in resolving the title dispute. I want to make this very clear. I'm interested in resolving the debt severances only. Now, if you don't own an interest in the land, then you can't have a debt severance that we need to consider, and that's important for us to understand. So what we need to do is we need to schedule a date in which Mr. Hubble is available and Mr. Shaw is available, and maybe even Mr. Mocketh is available. And is there any other witness that you think is relevant to the debt severance issue?
No, and we believe that Mr. Shaw's testimony supports that Ms. Bell owns an interest in 25146.
Fine.
Yep.
Mr. Savage, did you have a landman that dealt with debt severances? I don't remember.
Mr. Shaw.
Oh, it was Mr. Shaw.
But may I respond to that approach that you described?
ahead.
Okay, thank you. So both testimonies, the new testimony, which we think is unauthorized testimony that they provided, talks about gaps, possibilities. Currently, they believe, but if there's new additional information, they might change their mind. Mr. Shaw also talked about gaps, some gaps that they couldn't necessarily confirm. Okay, so it is my understanding that Ms. Bell only needed to meet a threshold of ownership.
Why are you arguing Ms. Bell's case? I don't understand that.
Because it relates to, I explained in the motion that we submitted that it addresses correlative rights, and that she kind of stands as a proxy to highlight the violation of correlative rights that VF's competing application does not do, that Permian Resources application does.
I understand how the correlative rights issue helps your competing case. That's obvious to anyone who has sat here for as long as I have during these hearings. But Ms. Bell has counsel. I expect Ms. Bell's counsel will argue for her client. You'll argue for VF. But I understand how the interests blend at points, but I'm not looking to you to argue. What I want to do is I want to take more evidence on the debt severance issue.
So can I give an example of what of how the OCD in the past has viewed claims of ownership? Okay, so there are some orders regarding parties applying for permits, and I don't have the name on top of my head, but I can give you copies if you request. So in party operator claimed interest, which is a requirement to get a permit, the other party challenged that interest, say you did not own any interest. Okay, what the division ended up ruling, because it cannot adjudicate title, it said we are going to take on good faith that the operator, the claim, and therefore the applicant for the permit meets the threshold to have standing in the case, which the OCD ruled on, the same as Mr. Hearing Examiner that you ruled on. So at this point, especially since Permian did not even give the proper pleading to have a reconsideration of the hearing, at this point, the one owner that appeared that has a severed interest has made an appearance, has made the claim, has met the threshold. VF is involved in this case. We have a vested interest in preserving the integrity of the hearing.
Mr. Savage, whether or not Ms. Beal owns an interest in 25146 matters, because we know she is not contested that she owns an interest in 25145. Clarity. We have to point to compelling, relevant, reliable evidence in the record to make a decision. And at this point, there are still questions.
Then if I just may want to add one last point.
Of course.
So if Mr. Shaw will testify, if he can provide title documents that show those severances, those would be admissible. If they have not already been presented.
We're going to schedule a hearing to continue because we don't have any witnesses available today. So I'm going to ask you, Ms. Bell, when Mr. Shaw is going to be available. Okay. And I'm going to ask you when Mr. Hubble is available. And then if there are, Ms. Luck, if Mr. Shaw has some other document, he needs to share it before the hearing with Ms. Vance so that Ms. Vance can have her party look at it. Because we can't keep doing this forever.
No, I understand, Mr. Hearing Examiner, and I believe that what we filed in advance of the hearing properly and her notice of ownership interest and objection to the proceedings, that properly is there was 4 documents attached. Those 4 documents properly established her interest ownerships in the 2 cases where I've been allowed to proceed.
Are you talking about what you filed on February 6th?
Yes, sir.
Okay.
Yes, and I can get to you those commission cases that Darren's talking about where it's properly in established division policy, precedent, all of those things that under case 12731, 12744, the burden is on the operator to establish a good faith claim to title. But the division has no jurisdiction to determine the validity of any title. And that's the only reason Permian wants us to come back here and offer more testimony, is determine who owns what out there. And Ms. Bell has already properly established she has an ownership interest in the Third Bone Spring, and that's why she has shown up in these proceedings. And I'm sorry, me and Mr. Savage work together, but I hope that I properly argued that this is a correlative rights issue, and that's why I continue coming to these hearings, because Ms. Bell owns an interest in the Third Bone Spring that's being essentially just segregated from the Third Bone Spring pooling application, cut out, not being allocated anything to her interest in the Third Bone Spring. And we've properly established that. Mr. Shaw showed up and explained very clearly the interest she owns in the Third Bone Spring.
I was here. I actually have a summary here of Mr. Shaw's testimony.
Mr. Hearing Examiner, since both VF and Ms. Bell have.
I was going to come to you, but I wanted to say something to Ms. Luck. Ms. Luck, we're not here to establish who owns what. We're here to decide if there are depth severances. I must have said this now 4 times. So please don't misunderstand me. We're not here to dispute title ownership. We're here to figure out where the depth severance lay so that we can evaluate the competing cases. That's all we're here for. And we can't do that if there is a dispute over ownership, because if there's no ownership, then there can be no depth severance in that section. Does that make sense to you?
No, I understand that, but the title opinion doesn't explain the depth severances. So that's why the title opinion should not even come in here. If that witness didn't sign the affidavit, the person who signed the affidavit didn't support the title opinion with any additional information. The title opinion is only being provided for the purposes of determining title, which is improper over here.
Since the division doesn't determine title, it wouldn't be used for that purpose. So I can't explain. Ms. Vance can speak for herself on why she included that opinion. I'm going to give her an opportunity in a moment, but it seems as though it's when we come back on the record, when the witnesses are available, you will have ample opportunity to cross-examine Mr. Hubble based on his opinion, and you can offer your own, Mr. Shaw, to counterbalance that testimony as well. So does that make sense to you?
Well, yeah, I just want to be sure that this testimony is being limited only to the location of the depth severances. It looks like on their exhibit, there's 2 depth severances in section 14, and I want to be sure that we're not talking about striking Ms. Bell's entry for any other title flaws or gaps or disputes with regards to title.
All right, I've made myself very clear, Ms. Luck, so I can't say it any other way. And I'm the one who allowed you to intervene, and I haven't reconsidered that decision, so there's really nothing to talk about there. Ms. Vance?
Yeah, I just want to be very clear. Again, we don't dispute that the division doesn't have jurisdiction over title. We have not included any title instruments because we stand by that statement. Now, there have been a lot of title instruments that have been filed by both of the parties that go to the two depth severances that we have described in our own exhibits. So I just want to be clear, we are not asking for title adjudication. And what was filed was not filed in bad faith. It was filed to answer a question, a request from the technical examiner. And we cannot provide a depth severance if a party does not have an interest.
Okay, that's clear. Okay, do you know when Mr. Hubble is available?
I do not, but I will, I just learned right before we came to the hearing that he wasn't going to be available. But I am happy to talk with my client and find out when he is available and then confer with Ms. Bell's counsel, Ms. Luck.
Right. And do you know when Mr. Shaw will be back from El Paso?
I am not sure when he will be back from El Paso. I assume that's soon. But if we could just coordinate with dates with Permian's counsel, that would work. Thank you.
In other words, the parties will figure out when their witnesses are available and they'll advise the division. So let me just say now, I want to have this hearing as soon as possible. So Ms. Luck and Ms. Vance and Mr. Savage, I'm looking to have this next week. So your witnesses can appear.
I will be on military leave in a secure space and I will not be available.
Okay, when are you going to be available?
I will be available remotely. Well, no, I will be available the week of April 7th.
Okay,
I will be back.
That's fine. That gives you even more time to get your witnesses. It's delaying the consideration of your competing applications, and I'd like not to do that, but I don't have a choice. So, okay, so the week of April 7, so we're talking about a Tuesday, Wednesday, or Thursday. So would that be what, the 8th, 9th, or 10th?
That's correct.
And the 10th is a docket day, and we do hearings by affidavit that day. Freya, how many hearings do we have on April 10 right now?
I will look it up, but I just wanted to remind you that the OCC has a week-long hearing that week. So our docket on Thursday will be virtual.
Thank you. So, okay. So that means any of those days, 8, 9, or 10 will all be virtual then?
Correct.
Okay, very good. Now, Mr. McClure, I don't know, Mr. McClure, are you going to be the examiner on the 10th of April?
Mr. Hearing Examiner, that is correct.
Okay, perfect. So depending on how many cases we have, maybe we'll just add it to the end of that docket since you'll already be here for the hearings by affidavit. Freya?
Right now, we have approximately 70 cases on April 10th.
Okay, why don't we limit that docket to make space for this so that we can hear this at the end of that docket? Why don't we limit it to 50? So let's limit it to 50 now. Anything more than 50 move, and who knows, it may come down from the 50 based on continuances or objections or things like that.
Okay.
So, Ms. Vance, Ms. Luck, April 10th. Okay. If for some reason Mr. Hubble and Mr. Shaw just cannot make it on April 10, then let's then offer them 8 or 9, April 8 or 9, and we'll be flexible with the time on 8 or 9. But I'd rather not bother Mr. McClure if we don't have to. I'd prefer April 10.
That would be my preference too, just because I have court hearings on the afternoon of the 9th and then on the morning of the 10th.
Great, then let's get Mr. Shaw and Mr. Hubble strapped down for the 10th. Okay, and we'll hear it at the end. Sorry, Mr. McClure?
I'm sorry, Mr. Hearing Examiner. I was just going to mention if we could have Mr. Maka available, that would be useful as well.
Thank you, Mr. McClure. I appreciate that. And the hearing will be on the issue of debt severances. Now, ostensibly, we're dealing with these motions to strike, but underlying these motions to strike is the debt severance issue, and we need to get evidence on that. Okay, is there anything further from the parties?
No.
I don't know if you want me to make her ask to be able to respond to one issue.
Go ahead.
Okay. So VF views that if the division takes the evidence of Permian and decides that there's no ownership, and as a result that there's no debt severance, the decision itself of that there's no ownership is a adjudication on ownership and title. See, it's kind of a catch-22.
But it's not, Mr. Savage, because the division is looking for evidence of debt severance only. Now, if that entails the fact that I understand your perspective. But obviously, we're not adjudicating whether or not there's an interest. So if Ms. Beal finds that the division made the wrong decision about a debt severance, then she can go to court and have that adjudicated there.
Let me add one more example, and I'll be quiet.
I'm not asking you to be quiet, Mr. Savage.
So let's say that the Permian's title opinion witness attorney says, here's a document. It shows that. So say there. Here's a document. Here's a document shows that she has interest. Here's a gap. Here's a document that shows she doesn't have interest. Here's a gap. Here's a document that shows she has interest. Okay. So this document that shows she has interest also has the debt severance.
Okay.
Okay. So you would rule out validating this last document in the chain and the validity of that debt severance because you would adjudicate that she doesn't own any ownership. She has no ownership because of this document.
I understand.
But there's gaps. And so there's no way to confirm what the title is. And the OC doesn't have jurisdiction to confirm that.
Ms. Savage, and I'm not going to forget the last three cases.
And I would like to say one thing in response to that.
Okay.
I definitely want to be able to respond because Mr. Savage has had a lot of leeway on talking today, and I would like to respond.
Let me first, Mr. Savage, the division deals with administrative adjudicatory cases by a preponderance of evidence. Okay, that's the standard of evidence at the.
Except for a determination of ownership. There's no preponderance of evidence.
We're not dealing with ownership. We're dealing with the debt severance, the location of the debt severance. So I understand that in your mind they're so tied together that you don't see one without the other. Okay.
I do. I actually do see one without the other. I think you could take an individual title opinion, a title document that specifies the location of debt severance at 9400, and regardless of whether Beal owns or does not own,
that's right.
You can say that's the location of the debt severance.
That's right.
Anymore, it becomes an adjudication of ownership, taking one side or the other.
Okay.
Okay.
I understand that perspective very well. Ms. Vance?
Yes, just a couple of a couple of points to make is via Ms. Beal, they want to have it both ways. They want title, they don't want title. Okay. We have provided something not to substantiate title dispute, but to discuss whether or not a debt severance exists or not. And that is purely what it was provided for, not to get into the merits of a title dispute, which belongs in a district court. So I just want to make that clear that that is what we're trying to do.
Okay, thank you. Okay, let's finish the docket by going back to the first three cases of the day.
And thank you, Mr. Herrington, for letting me give my final response on that. For sure.
May I be excused? May I be excused?
Are you not involved in the first three cases of the day?
I don't believe so, no. Thank
I
you.
didn't know if you were or not. Okay. Very good. Yes, by all means. Thank you.
Thank you.
We'll see you on April 10, if not April 8 or maybe April 8. I don't know. Okay. I think I called the first three cases on the docket, Matador Production, 250353738. So I'm recalling them now.
Paula Vance on behalf of Matador.
Yep.
Darren Savage on behalf of Cimarex Energy Company.
Mr.
Miguel
Savage.
Suazo on behalf of XTO Energy.
Thank you, Mr. Suazo. I forgot that you were still there.
No problem.
Okay. Mr. Suazo, I think you said that you had withdrew your objection in these cases?
Correct.
Okay, thank you. And Mr. Savage, what is your status now on these cases?
Well, I think we left this off with the need for a motion hearing.
Yes, the legal issue.
The legal issue to
Yes.
be addressed.
We did.
Okay.
But did you discuss it with Ms. Vance?
Yes, and can I just interject and say, I don't think we need to get into legal arguments.
Okay, all right.
What I would ask for, because I think that we still have some things to hammer out between the parties,
Okay.
is that we either, I know you have it on here that it's the last status
I did,
conference.
yes.
But I would ask for a little bit of grace
Okay.
to do one additional status conference, because I believe we can probably resolve this issue without having to, get into doing contested hearings or anything like that.
And when you say this issue, do you mean resolve the objection as a whole?
Yes,
You do?
resolve the
Okay.
objection. I think that the parties just need to communicate. And if we have a little bit more time, I think we can probably resolve this
Mr.
without.
Savage, do you agree?
Well, that sounds like a fair offer. If we could have the status conference at in a timeline that's a little bit further down the road, say in June, to complete.
That's longer than I was willing to do this based on the age of the cases.
Okay.
I already had them marked as a final status now. I will grant another status conference and not set a contested hearing, because I was ready to set May 13. So why don't we say that we'll have a status conference April 22nd? And if you have not resolved your issues, we'll either deal with the legal issue or we'll go to a contested hearing either in June or in July.
Yeah.
But that still gives you plenty of time to resolve this before.
No, I think that's fair. I appreciate that.
So then, Ms. Vance, they're your cases. Would you move them to the April 22nd docket for yet another final status conference?
Yes, thank you.
And good luck on your military. Oh, and we're off the record. Thank you, Freya. And good luck on your